So if you have a small business and you file bankruptcy, can you continue to run your small business? Watch my next video, find out. So in this day and age, it seems like almost every other client that I do consults with, they have some kind of side business. And it's not maybe their full-time gig, but they may have, a small business. They could be a sole proprietor, have an LLC set up. But anyway, they want to know, if I file bankruptcy, is the trustee going to make me shut down my business? So the answer to that is maybe. Now, I have rarely seen a trustee tell a client they have to shut down their business, especially if your business is, for instance, you're a consultant. Especially folks that they're not really dealing with inventory and products and things like that. They're in a services business. Thank goodness the trustee can't sell you, and so it doesn't, that the trustees really don't care, about you continuing your business. Now, it matters in terms of which chapter you file, how it's treated. So let's talk about Chapter 7. Yes, when you file a Chapter 7 bankruptcy, a bankruptcy trustee, if you run a small business, they could most certainly tell you, you have to stop operating the business. I'm going to value the assets, and we look at what we can't protect, right? Because we have exemptions, and we can use some of those exemptions to cover your business assets, your personal interest in the business assets. But a trustee could say, you're going to stop the business. We're going to value inventory, accounts receivables, all that. And I'm going to include that, in the liquidation so we can see what we can get for it. So that could most certainly happen. Let me give you an example. I have had a couple of folks in the restaurant business. So if you're in the restaurant business, don't think that you're going to be able, you've got a small restaurant, that you're going to be able to then file a Chapter 7 bankruptcy, but still keep running your business when your business has all of this, inventory. You're going to have food, you're going to have, your tables, chairs, decorations, all of this stuff. Now, again, a trustee may not care about it. And so I'm not trying to scare folks, but it's something you need to be prepared for, because you don't want to get blindsided when you file a bankruptcy. You don't want, oh, my attorney told me that this wouldn't happen. No, a trustee has every right. If you're filing bankruptcy because you're having financial problems. So that's just a fact. That's why you're in front of this trustee. And the trustee, in a Chapter 7 case, the trustee, their job is to maximize how much they can get out of your assets that are not protected by exemptions to pay your creditors. That's their job. So if you, in this case, I had someone come in and they were shutting their restaurant down, so it wasn't a big deal. And they had a lot of tables, chairs, they had some inventory. And so we disclosed it, we used the exemptions. In one of my cases, the trustee actually did take the inventory because they just had a lot of other things they sold in the restaurant that were over the exemptions. And that's fine. The trustee, just took it, sold it, and distributed a little bit to creditors. So that can happen. They can most definitely tell you, you got to shut your business down. And I will tell you, especially with Chapter 7 clients, a lot of times folks that have a business and they're filing Chapter 7, they're filing Chapter 7 because of their business, right? They've personally guaranteed a lot of debts. And so because of that personal guarantee, because the business is defaulted, now they're facing bankruptcy, so at least they can cover themselves personally, which is fine. But, also keep in mind, when you're doing a personal bankruptcy, that's still not going to excuse your business of the liability of the debts. 99.9% of the time when people come to me to do a Chapter 7 a business bankruptcy, they'll always say, oh, it's a business bankruptcy. No, it's a personal bankruptcy because of your business. But when they file, someone's like, oh, well, can I keep the business open? No. Why would you do that? Because your business still owes all those debts. They didn't go away. Just because you filed, you don't owe the debts anymore because you've done bankruptcy. But the business? Oh yeah, business still owes those debts. Business can get sued. Business can have their bank accounts garnished. So why are you going to keep the business open that owes debts, try to make money, and in the end, going to have to pay it anyway? That doesn't make any sense. And in that case, it makes more sense to just do your bankruptcy and establish a new business, new EIN, and start fresh, so that this new entity is not haunted by what's going on with this older one. Of course, talk to corporate counsel. If you've got trademarks, other intellectual property, things like that, you of course want to talk to, counsel about how that would be handled. But most of the time, it doesn't make sense that you'd want to have that business open. But, sometimes I have folks and they're like a stylist, and that's their business and it's an LLC. Well, yeah, the trustee is not going to tell you can't keep being a stylist. But if you already have debts that are associated with that business, it's probably going to make sense for you to stop doing business, at least under that business name, that business EIN, and look to establish, a new business. So again, it's not haunted by that debt. So let's talk about Chapter 13 bankruptcy and small business. Do you have to shut it down? So Chapter 13 bankruptcy is a debt consolidation reorganization, and a lot of folks are self-employed when they have to file a Chapter 13. So it's a little different. The Chapter 13 trustee, they don't sell your things. That's not what they do. So very different than a Chapter 7. But if you are a small business owner and you have a small business, just know that the trustee they'll usually, if it's a big enough business, they can set up a time to have a special business hearing, because they're going to get into your nitty gritty. You're going to have to do a profit and loss statement. If your case gets approved, you're going to have to submit quarterly reports to the trustee, because especially if you're a self-employed person and you're not paying your creditors back in full, then you can better believe the trustee is going to have you accounting at least every quarter to see, because your income goes up and down, to see where you're at. And if you start, if your income, your business starts producing more and more money, then hey, maybe you are going to be able to afford to repay, some of your unsecured creditors some money, whereas when you started, you weren't. So just heads up, it's going to be more paperwork. But in a Chapter 13, the trustee's not going to tell you to shut your business down. They're just going to say, hey, we need to see that this is a business, that this is making money, because if it's not making money, what's the point, right? Because if you're in a 13, you're supposed to be rehabilitating and repaying. And I always tell clients when they're self-employed, hey, if you're in a 100% plan where you're paying back your creditors in full, you're going to get less of a hassle by the trustee, and that's just the truth, because you're paying everybody back. So of course, the trustee is still going to review your documents, but they're not going to be as into your business, as somebody that's not repaying everybody in full, because they're like, well, this person's paying everybody back. It's just they're restructuring how they're doing it. But just know, if you are a small business owner, you're going to have, it is a little bit of a different process for you than someone that's, that is a, W-2 employee. And again, most of the trustees aren't going to get too into your business. If you have, if you're a single member LLC, you're a consultant, or you're a stylist, you're a real estate agent, or an interior designer, something like that. They're not going to get too into it. But like, let's say, you have a leasing company, you sell products, things like that. Yeah, all of that is going to come into play, and it's a much more detailed case. So just have that conversation with your attorney when if you're thinking about filing bankruptcy, but don't assume you're going to have to shut your business down. It's just, it just depends. It really depends on your specific situation. I hate it when people will call me and they're like, I know I have to do this. I know I have to do that. Well, no, not necessarily. So beware of Google law. It can get you in a lot of trouble. If you have any, let's talk about one other thing. Partners. So what if you have, you don't own the business 100%. What if you have business partners? What if you have a minority share? What's going to happen if you file bankruptcy? How are your partners going to be affected? So I always tell folks, if you are having financial trouble and you think bankruptcy could be in your future, you need to sit down with your business partners and you need to tell them, I'm contemplating filing a bankruptcy, because there may be some amendments that need to be done to your operating agreement, to your partnership agreement. There may be some pre-filing things that need to be done so that your partners can protect the company and whatnot from a trustee. Because there could be situations where if you're in a Chapter 7, you file bankruptcy and you have an interest in a company. I mean, your shares, I mean, that's a value. That is an asset. And so the Chapter 7 trustee is completely entitled to value that asset and then go to your other partners and say, hey, if you don't want me to liquidate everything, you got to buy me out. You got to buy out these shares. So again, that's when you guys need to look at your corporate formation, your corporate documents. Speak to your corporate counsel. If you don't have a corporate counsel, make sure you find a good corporate counsel, because this is why sometimes doing things like LegalZoom to do your company is not a good idea, because you can get sticky, and a lot of typical boilerplate operating agreements, partnership agreements, they don't have a bankruptcy contention in there. Some do, but just again, make sure you speak with corporate counsel about it. Because if you are a partner, a shareholder, this could affect the other folks that you do business with. So make sure. And in terms of if you're in a 13 and you're in a partnership or you have a minority share in an LLC or corporation, it could still come into play, because if you have to do quarterly reports, that's a burden on the company. Your company's still you're gonna have to have access to it. You're gonna have to be able to produce all of this. And you need to make sure that you disclose that to your business partners, because that's gonna affect them too. So if you are in that situation, if you're not a sole proprietor or 100% owner of your corporation, you need to talk to your business partners to see how you guys want to handle that. And sometimes that's a conversation with corporate counsel. Sometimes, I'll do conference calls with corporate counsel, and everybody involved. So we have a plan, and hey, this is how we're going to address it. But it's important to make sure that that's all disclosed. If you have any questions about filing bankruptcy, at least here in Georgia, please don't hesitate to reach out. My information is below, and I'm always happy to answer questions about bankruptcy.